Our legal system in Canada is renowned around the world for its fairness, equality, and justice. However, what if I were to tell you that it's preventing criminals from going to prison? What if I were to tell you this was most prevalent in the most serious criminal charge in the Criminal Code of Canada, first-degree murder? The cause of this crisis? Burden of proof. Now, the Crown Counsel must prove, as outlined in Section 231 of the Criminal Code of Canada, that the murder was planned, deliberate, and that the accused committed the crime, actus reus, with intent, mens reus, at the exact scene and time of the incident. This requires an enormous amount of physical evidence, as well as for the Crown to prove all of this beyond a reasonable doubt. Now, the Crown must provide circumstantial and direct evidence that the accused committed the crime at the scene, as well as evidence that he deliberately planned this action. This means that not only do you need to show that he was there at the time of the incident, i.e. fingerprints, as well as that he committed the act, with i.e. a murder weapon, you also need to show that the victim died because of his exact planned actions. Therefore, police must investigate all aspects of the accused prior to the incident and obtain all this evidence properly through the Canada Evidence Act. As outlined by Rick Woodburn, a Nova Scotia Crown attorney, 10 years ago, my files for a homicide case were a couple centimeters thick. Now, they're 2 to 3 banker boxes full. Even if the prosecution was able to acquire all of this evidence, it can be easily dismissed through pretrial motions set by the defense counsel using our own Charter of Rights and Freedoms. As outlined by Judge Moldaver, who presides over the Ontario Court of Appeal, the bulk of responsibility for the length of time it takes ordinary criminal cases to get to trial lay with defense lawyers who then were filing a barrage of pretrial motions alleging violations under the Canadian Charter of Rights and Freedoms. Let me ask you this. Is it fair that evidence clearly pointing to the guilt of someone accused of first-degree murder should be dismissed because of unreasonable search and seizure? Secondly, even if the Crown Counsel has gathered all of its evidence, it has to prove the case beyond a reasonable doubt, which means that no logical person has any reasonable doubt towards the guilt of the accused. The problem with this arises in proving the actus reus and mens reus of the case. The Crown Counsel then has to prove that nobody else was at the scene who could have committed a crime, and also has to prove that the accused had no other reason to commit it, i.e. insanity or self-defense. The metrics to prove this is insane. Not only do you have to prove the guilt of the accused, you have to prove that everyone else was not guilty. Stop and think about this. Even if none of the 12 jury members have any doubt from either the Crown's or defense's submissions, the prosecution still has to hope that the jury isn't biased. This is because juror members can be hesitant when convicting an accused of such a serious crime such as first-degree murder, which carries a charge of 25 years to life. With all of the aspects that the prosecution has to prove, the cards are definitely stacked against them. Now, some might argue that this high burden of proof was put in place in order to protect the integrity of the legal system by preventing innocent people from being convicted. But let me ask you this. Is having a few innocent people in prison really worse than spending exorbitant amounts of money on prolonged trials, as well as risking the safety of our society? I would imagine that many people would rather live in Canada if it were protecting its citizens instead of being overly fair.